This was supposed to be a done deal, a 17-year-old ready to walk away with a plea. But one decision behind bars changed everything in seconds.
I thought this was set for a plea.
Well, it was, so they would
I'll give the court explanation, Your Honor.
it was gonna.
Judge, we discussed what I thought was going to be a solid agreement, and then after reviewing jail disciplinary, I just didn't think the court would approve it. So my offer was being refused.
Yeah, just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket today to plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jail write-ups, which I've been provided with, and that the offer was now 6 years and with a 7-year cap, and Mr. Carter previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you?
17.
17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right?
Yeah.
And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man. But you are in felony court like every other grown-up man. And if you make kid decisions and think that horse playing and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And that's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him to a second degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible second-degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range from a third degree to a second degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a second-degree felony instead of a third, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have your case set for trial. We've talked about all that. Do you want to reject that offer and have a jury decide? Okay, then we'll get your case set on the trial docket as quickly as we can. Again, don't get over there and forget what I told you today. It's very important. Do you understand? Okay, go back with the bailiff. All right, sir, you're Stephen Wilburn?
Yes, ma'am.
This is cause number 24, DCCR 2346. Mr. Wilburn was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
Any more, Judge?
Judge, although safety was not part of the original plea, obviously, of course, it's up to the court's discretion, and based on Mr. Riley being so thorough in his PSI, I would stand with his recommendation.
Your Honor,
Seeing as how he put it out in bold, et cetera, that safety or some other form of residential treatment proposed.
Your Honor, I would just point to the court that his last offense was 24 years ago, and he's got a full-time job. He worked for Performance.
Yes.
I think he's a welder.
Yes.
And we would ask that he not be sent to safety and be monitored some other way as far as his alcohol consumption. Obviously, he understands that he can't drink. He and I have talked about that.
Or possibly hold that in abeyance, Judge, if you're considering, so that, I mean, my concern is over the holiday period, if we're not here, it could be brought to the probation department's attention and then the courts, even if we're not done.
All right, makes sense. So here's what I'm going to do, Mr. Wilburn. Obviously, you've had a very long-standing issue with, it appears to me, with alcoholism, and I understand that you're Mr. Parker's position. Your last DWI was a very long time ago, but your history prior to that was not good, and I don't want you to go down that same path, obviously. So what I'm going to do is I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, follow the agreement, and find you guilty of driving while intoxicated, third or more. Sentence you to a term of 10 years in prison, but probate that for 6 years. You will be ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That means some of those rules and conditions are the standard rules, but in addition, I am going to order that you enter and successfully complete the SafeP program, but I'm going to hold that in abeyance. What that means is that it's already ordered. If there's any hiccup at all, two things could happen. One, they could just send me over a piece of paper, it gets signed, you go to SafeP, period. I've already ordered it. Two, I don't have to do that. You could be revoked. So it's very important that you follow all of the rules. I am going to order that you enter and successfully complete the JCDI program. That is an intensive outpatient treatment program. So you will be ordered to successfully complete that. You will get started on that. Your officer will let you know how to do that. I am also going to order, at least for some time, that you wear a scram device. That's a device that will detect alcohol in your system. If there is any alcohol in your system, obviously you're either in SafeP or you're in prison, one or the other, immediately. And so you need to get that scram device within 48 hours of today. They'll also let you know how to get that taken care of. And you're also ordered, as a condition of your probation, to serve 10 days in jail. That's required. And so what are your hours of work?
Right now, we're on 7/10s until after Christmas, but we are having 3 days off for Thanksgiving. I can start them 3 days. I'm sure we'll have a few days off for Christmas.
Well, it's difficult to just say, okay, you're going to do 3 here and 7 in a month or two. I mean, obviously, I don't want you to lose your job, but we've got to get the 10 days done. So what I will do, I mean, you have some time off on vacation, things like that, that you can take. I don't mind doing a longer period of time over the Thanksgiving break, and then do y'all want to look at a calendar and come up with 10 days, Mr. Parker?
Is it 10 days consecutive?
It does not have to be. No, you can do weekends, and I don't mind spreading it out a little bit, but I need specific dates. 10 specific dates between I mean, we're already in November now and the end of the year. I wouldn't mind working a little bit around that, but I need the exact dates. So why don't y'all talk real quick about those dates, and then I'll recall the case and I'll put those on so we have those for the order. All right, this is back on the record, and what are the dates?
He wants to start November 26th at 6 p.m. and then he'll do 26 through 28.
Yes.
And then he'll do every weekend after that, reporting it Friday at 6 p.m.
So that every weekend then would start on the 5th of December. I mean, because the 28th is a Friday, so you don't want to go ahead and go through that weekend?
You're going to do Get Out Sunday, correct?
Yes.
So it would be the 26th through the 30th then?
So is the 30th a Sunday? Mm-hmm. Yeah, you Get Out Sunday, yes.
Okay, so the 26th through the 30th, so we've got 26, that's 4 days. And then we need every weekend, starting December 5th, until it's satisfied. So you will report then on Wednesday, November 26th at 6 p.m. You'll serve 4 days to be released on Sunday the 30th. Then you will report back that next weekend, Friday at 5 o'clock. They'll let you out on Sunday, and that will be until you complete the remainder of those 6 days. It's important that you are on time, not late, that you show up every Friday. It's a condition of your probation, so if you don't show up or you're late, then you're in violation of your probation. It's also very important that you don't show up intoxicated. Some people think it's a great idea to show up drunk. They're going to sleep it off while they're there. That's a violation, so don't do that as well, okay? All right, have a seat here in the courtroom. Probation will call you up. Actually, hold on, I didn't finish this. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
In the end, it wasn't just the crime that sealed his fate, it was his choices after it, because in that courtroom, every action speaks louder than words.